Another important landmark judgment of the Supreme Court that we will discuss in this lecture is relating to Sajjan Singh versus State of Rajasthan, which was decided in the year 1964 relating to the 17th Constitutional Amendment Act 1964 relating to Article 31A and those 44 acts which were inserted into the ninth schedule of the Constitution and also relating to the amending powers of Parliament under Article 368, which relates to amending the fundamental rights which we found under Part 3 of the Constitution, also the High Court's powers under Article 226 of the Constitution. Then, what is law and the very scope and definition of law as per the provisions of Article 13, Clause 2 and the difference between amendment and an act of parliament. So, we would like to discuss exactly the facts that relate to this particular important leading case as Parliament passed the Constitution 17th Amendment Act 1964, by which Article 31A was amended. 44 acts were added to the ninth schedule of the Constitution in order to preserve the legality of those acts of relating to land reforms as well as of other acts that were likely to be struck down. So, people who were impacted by one or other of those acts were the petitioners and interveners in the writ petition filed before the Supreme Court, and those issues involving the act relating to this landmark judgment is that what would be the requirement about making an amendment in a constitutional provision contained in Part 3 of the Constitution, if as a result of the said amendment the powers conferred on the High Courts under Article 226 of the Constitution are likely to be affected, whether the word law as provided under Article 13, Clause 2 of the Constitution excludes an act of the Parliament of India regarding amending the Constitution, whether Parliament is competent to make any amendment at all to Part 3, which relates to the fundamental rights of the Constitution. So now we would like to discuss those laws which involved in this particular leading case in relating to the provisions of Article 31B, then Article 368 and Article 226 and Article 13 Clause 2 of the fundamental rights. So, in particularly, Article 31B of the Constitution provides none of the acts included in the Constitution's ninth schedule will be regarded to be void or to have ever been void, as while Article 368 provides the methods by which Parliament may amend the provisions of this Constitution, and in particularly Article 226 of the Constitution gives the High Court the authority to issue direct tips, orders, or rates, including rates of habeas corpus mandamus, prohibition, quo warranto, certiorari, or any of them to any person or authority, including the government. So also, Article 13, Clause 2 of the Fundamental Rights provides that the state shall not make any law which takes away or abridges the rights conferred under Part 3 of the Constitution, and any law made in contravention of this clause shall, to the extent of that contravention, would be void. So now we would like to discuss the very contentions of the petitioner relating to 17th Amendment and Part 3, the Fundamental Rights, and Article 226 and Article 368, and in connection to that there would be a re-examination of the important leading case that already we have discussed, Shankari Prasad case and Kameshwar Singh case. So also entry 18 of list 2, which is state list. So the very contentions of the petitioner is that powers prescribed by Article 226 of the Constitution are likely to be affected by the 17th Amendment of the provisions contained in Part 3 of the Constitution. So specific procedure outlined in the provision to Article 368, which calls for the ratification by at least half of the states, should be followed. Further, the contention of the petitioner is that it is important to re-examine the ruling laid down by the apex court in those important leading cases such as Shankari Prasad Singh versus Union of India and State of Bihar versus Kameshwar Singh, which rejected the argument in relation to the first Constitutional Amendment Act of 1951. Further, the contention of the petitioner was that the bill introduced for the purpose of making such an amendment must attract the provisions, and as the Act has admittedly not gone through the procedure prescribed by the provisions, it is invalid. Further, the contention of the petitioner was that true purpose and object of the Act is to legislate in respect of land legislation. In respect of land falls within the jurisdiction of the state legislatures under entry 18 of list 2, which is a state list, since the state legislatures alone can make laws in respect of land. Parliament had no right to pass the Act. And further, the contention of the petitioner was that power to amend, which is conferred by Article 368 of the Constitution, does not include the power to take away the fundamental rights which are guaranteed by the Constitution under Part 3 of the Constitution of India. Now we would like to analyze the very judgment as relating to fair and consistent interpretation of Article 368 and on restricting High Court's power, and further the doctrine of Pith and substance. Relating to this analysis as per the effect of amendment on power of High Courts under Article 226 of the Constitution. For majority opinion, the main part of Article 368 of the Constitution and its provisions must under a fair interpretation and be consistent with one another. Further, the analysis led to such an interpretation mandates that it would be required to evaluate whether the provisions to Article 368 of the Constitution would apply in such a circumstance if amending fundamental rights was to significantly restrict the High Court's authority of judicial review was provided under Article 226 of the Constitution. Further, it led to the caveat might not apply if the effect is indirect, incidental, or otherwise of a minor order. Finding the essence and content of the contested act is the standard to be used when addressing such a matter. And regarding the faith and substance, if the very test, faith and substance test is applied to the amendment made by the act, it is evident that the Constitution 17th Amendment Act only modifies fundamental rights in order to remove constraints on the implementation of socio-economic policy. It has a minor accidental impact on Article 226 of the Constitution. As a result, the Act is covered by the substantive portions of Article 368 and is exempt from the very purpose or the provisions. So, now we would like to discuss how far the judgment is relating to reconsideration and re-examination of the important leading case that already we have discussed in our previous lectures regarding Sankari Prasad versus Union of India and State of Bihar versus Kameshwar Singh. So the question about the validity of the Constitution First Amendment Act was considering in Sankari Prasad Singh versus Union of India and State of Bihar versus Kameshwar Singh. One of the grounds of challenge was that the newly inserted Articles 31A and 31B sought to make changes in Article 226 of the Constitution. This contention was rejected by the judgment, observing that the said articles did not either in terms or in effect seek to make any change in Article 226 or in Articles 132 and 136 of the Constitution of India. So far, majority opinion in the present case, that is Sajjan Singh versus State of Rajasthan in 1964, the Constitution is a living document created to act as a roadmap for resolving complex issues. However, the court should be reluctant to agree to the proposal that its past rulings should be casually re-examined in such a situation. The key question is whether it is absolutely necessary to revisit the already settled questions in those previous two important judgments delivered by the Supreme Court. So the amendments of 1951 and the amendment of 1955 as well as the judgments pertaining to the legality of the acts in the ninth schedule would be put in considerable peril if the petitioner's claim were to be accepted. Further, for minority opinion, the attack in the 17th Amendment Act was based on the grounds of most of which were the same as those urged and rejected in the earlier case of Shankari Prasad Singh. No case made out by the petitioners either for the reconsideration of that decision or for striking down the 17th constitutional amendments. And now in that connection we would like to discuss the very powers of Parliament regarding amending Article 368 of the Constitution in relating to Article 13, Clause 2, which defines what is law and the very scope of law, then Part 3, which relates to fundamental rights, and the very 17th Amendment Act of 1964 and its relation to Article 31A and 31B. Also, the 19th Constitutional Amendment, the 1951 Constitutional Amendment, which was the first amendment in comparison to 1954 and 1964 Amendment. So, in the very contract or context of the Constitution, this includes the authority to modify, change, or even amend the provisions such that they are inapplicable in specific circumstances to those included in Part 3 of the Constitution. The fresh amendment of the Constitution clearly and unmistakably refers to changing all of its provisions. The provisions language makes it clear that the substantive part of the article applies to all of the Constitution's provisions. Further, Parliament in enacting the 17th Amendment Act was not making any provision of land legislation. For majority opinion, the Parliament was just approving land legislation that had previously been enacted in that regard by the state legislatures. Further, Parliament may validate laws which have been declared invalid by courts. Authority granted to Parliament by or under Article 368 may be used both in the present and in the past. Parliament has the authority to uphold legislation that have been used and ruled unconstitutionality by the courts. So, a legislation approved by Parliament with its inherent authority to amend the Constitution is not a law as defined under Article 13, Clause 2 of the Constitution. The makers of the Constitution would have taken the care of inserting an explicit provision in that respect if they had intended for any future revision of the provisions relating to fundamental rights to be subject to Article 13, Clause 2 of the Constitution. For the power to amend as provided regarding Part 3 of the Constitution, the idea that the fundamental rights in Part 3 were meant to be fixed and established once and for all without the possibility of further amendment would not be a realistic one and wish to continue. The very concepts of public interest and other crucial considerations may change and expand as a result of the socio-economic issues that legislatures may occasionally have to deal with, and further it is reasonable to assume that the constitution makers were aware that Parliament should have the authority to amend those rights in order to address the challenges presented by potential issues. Therefore, the fundamental rights protected under Part 3 of the Constitution could not have been meant to be everlasting, inviolative, and beyond the grasp of Article 368 of the Constitution, which relates to amendment. And if Parliament decided that adding Article 31A and 31B would be more suitable than following the laborious procedure of altering his pertinent article in Part 3 of the Constitution, then what Parliament did in 1951 was provided a legitimate foundation for additional amendments done in the year 1955 and 1964. So now we would like to conclude our lecture on discussing the very important leading case, that is Sajjan Singh versus State of Rajasthan. So, as per Article 368 of the Constitution, which empowers the Parliament to amend any article of the Constitution, while the very scope of Article 368 is restricted to constitutional law, Article 13 is only confined to ordinary legislation and does not apply to constitutional amendments. Further, Parliament has the power to amend the fundamental rights of the people conferred under Part 3 of the Constitution of India relating to fundamental rights. An amendment made by resort to the first part of Article 368 of the Constitution could be struck down upon a ground such as taking away the jurisdiction of the High Courts under Article 226 of this Constitution or of the Supreme Court under that of Article 32 relating to judicial review or under Article 136 without complying with the requirements of the provisions as underlined under these articles as per the Constitution of India would be declared as null and void. So, in length we have discussed in detail about the most important judgment delivered by the apex court or Supreme Court in the year 1964, and in particularly the 17th Constitutional Amendment Act, which relates to in particularly Article 31A and Article 31B. Besides that, those 44 acts which were included into the ninth schedule of the Constitution. And in light to that also, we have discussed regarding the amendment power of Parliament in relation to what is law as it is defined under Article 13, Clause 2 of the Fundamental Rights and the very amending powers of the Parliament under Article 368 of the Constitution, and also in relation to those powers conferred on the High Courts under Article 226 of the Constitution. Besides that also, we have analyzed certain other important provisions relating to Article 136 of the Constitution relating to the powers conferred to the Supreme Court.